Welcome back to Legally Speaking. I'm Amy.
And I'm Josh.
And this is just informational purposes only. We are attorneys here in Kentucky. Your state's laws may vary, and this is just for informational purposes only.
Yeah. Who doesn't love a good legal disclaimer? Right?
We have to do it.
All right, folks. Today we're going to talk a little bit about special needs planning. All the time we hear more and more about people that have their estate planning done, but they have loved ones, whether adults or even children, that are special needs individuals. Special needs meaning, they require some extra assistance. Depending on how severe their issues are, they may or may not be able to have their own decision-making capacity, not just as children, but even as they grow into adults.
Right.
And making sure that your estate planning encompasses that.
Yeah.
And properly handles it.
And a lot of individuals, children, and as they age up into adults, they qualify for special programs. One of the ones that we see all the time is the Michelle P. Waiver. It's a program that helps individuals with special needs be more active in their community, have jobs and friends.
Yeah, they get some assistance,
like
but they're usually able to stay in their home or in their own, residence that way.
Yeah, absolutely. And those types of programs have a waiting list of years.
Right.
2-3 years is not uncommon. So along with that, a lot of government programs also have income restrictions or asset restrictions because they are needs-based programs. And so that could go terribly awry if estate planning isn't done correctly.
Yeah, typically one of the things that we see too is a lot of times folks are on SSI, and that's true from people who get a disability when they're adults all the way back to if they always had a disability. Then they get the SSI, which is different than SSDI.
Yeah.
Again, another thing that's often confused. SSDI is the kind of disability you get if you have worked a lot of your adult life, and it's based on your income. You get an amount paid to you.
And yet you're no longer able to work.
That's correct. Yeah. So then you can't have earned income. Very different too, that SSDI, you can have an unlimited amount of assets. Your assets don't matter. You can't have earned income, but you can have assets.
So real property, money in the bank kind of thing.
Right. SSI is different.
Yeah.
It does have an asset component because that is true. If you're a person that had an issue from birth even and you've never been able to work, SSI is the program that you would be on.
Yeah.
And in that instance, that's what we're worried about maintaining with people doing their estate plans.
Yeah. And so one of the ways we do that is by setting up a special needs trust. And we do that either through a testamentary power, through like a last will and testament, or sometimes we just set up a soup to nuts special needs trust.
Yeah.
And
if we know that we've got, like, let's just use an example, kind of something we can nail it to here. If we have, a couple in their 40s comes in and they've got a child with special needs, okay? Generally, I like to go ahead and set up the special needs trust. It has a defined name. You can name that as a beneficiary because if we have mom and dad that have the special needs child and they pass away, leaving an inheritance to the special needs child, we may have a heap of problems. One is it's going to knock them right off their SSI until they spend it down, essentially. You don't want to do that. You want to be able to, if you're leaving your inheritance to your special needs children, you want to be able to augment what they can have. Okay?
And you want them to be able to enjoy a life and not have to worry about that kind of.
That's right.
Or have somebody else worry about it.
So what you want to do is keep their SSI in place, and at the same time, make sure that what you've left from an inheritance can be managed by a trustee, and that can be doled out to take them on vacations or to do other things that really improve their quality of life going forward.
Yeah. And a lot of times that also gives other family members, like grandparents, the ability to name that special needs trust in their estate plans.
Correct.
As well, so that extra family isn't going to run that risk of
once you have
trouble.
it's an unsophisticated way to refer to it, but I like to refer to a trust as a bucket because this bucket has the rules for what's in it, okay? And that's what you have to think of. Because too often we have people that have a trust and nothing is directed to it and nothing is retitled in it and it controls absolutely
nothing.
Zip. Right? Not a thing. So we got to get it into that bucket before it controls anything. So this special needs trust bucket is what we've got to get all those assets into. But once we have that set up, then yes, we can have other relatives, we can have the parents of the child, anybody can add things or direct things to fall into that special needs trust and maintain the other benefits that they would be eligible for if they did not have such significant assets left to them.
Right.
Now, tell us why. Is just any old trust going to be good enough for this?
No. Your trust has to have specific language that will grant your trustee the ability that if it's going to knock them off of some of their governmental benefits or make them disqualified for that trustee can essentially just liquidate the trust or do other things that can keep it from that child.
They usually have kind of a safety valve provision that says if it's not going to work or it's going to blow up any of the other government benefits they'd be eligible for, then the trustee can kind of blow up the trust.
Yeah.
But hopefully, what the goal is to have it a special needs trust more so than like when you talk about a revocable living trust. We've talked about that in one of our podcasts. We've talked about Medicaid Asset Protection Trust. This special needs trust, sometimes also referred to as a supplemental needs trust.
Yeah.
We've got to have different provisions in it still.
Yeah.
That says specifically in the specific legal jargon, right?
All the legalese.
That it's going to provide for their supplemental needs, but not their basic needs.
Right.
So their food, their lodging, all that supplemental needs trust, what comes out of there cannot be available to the trustee to provide to the beneficiary for that. If it does, the government's going to say, well, they have other money for their for their basic needs, and we're not going to provide as many benefits.
A term that you're going to hear a lot is a HIMSS or a HIMSS standard, health, education, maintenance, and support.
If your special needs trust has a HIMSS standard in it, the government is going to drive a semi-tractor trailer through it.
Right through the middle. And so another thing that we talked about, and you touched on this briefly a second ago, is sometimes a special needs person, whether it's a child or an adult, may not have the ability to make their own decisions. They may not have what we call decisional capacity.
That's right.
In that case, if it's a child, obviously the parent is going to be the guardian over that child. But when they become an adult, you have to switch that over to a guardianship and conservatorship. In Kentucky, and every state will vary. They name them different things. But here in Kentucky, it's guardian and conservatorship. So the guardian makes the healthcare decisions, decides where the person's going to live, just day-to-day types of things. Conservator, and yes, you can think of Brittany in this, controls the money.
You just stated yourself again, Amy.
The Brittany thing was just a couple years ago. Okay. It's not that old.
All right. But it was big news a while back.
Yes, well. But yeah, the conservator controls the money. And usually that's going to be the same person. But
Doesn't have to be.
Doesn't have to be. In order to do that, you have to go to court. Even if this person has been disabled their entire life or they have always had special needs that prevent them. When they become an adult, when you reach that age of majority at 18 years old, you have to go to court.
So at this point, we have to involve the court.
Yes.
In Kentucky, it's the district court. A district judge has to review the person's capacity and situation. There's going to be an interdisciplinary team appointed for this, right?
Yes. So when you have to go to court, you have to sign a petition basically stating why this person needs to have a guardian and or conservator appointed. And in that petition, you're going to lay out the reasons. And then after that petition is filed with the court, they will appoint an interdisciplinary team. It's comprised of 3 different professionals, a mental health professional, a physical doctor, like a physician, and a social worker, usually from the cabinet here in the area. And they'll interview the person, they'll talk to them, they'll review their medical records, and they'll make a recommendation to the court. Gotcha. For the most part, you're not going to have any problems with this. They're going to come back and say, yes, this person needs guardian and conservatorship. And you make an application when you do the petition, and you apply to do that. Now, there is going to be court monitoring. You have to provide ongoing reports of
accounting, the finances.
Yes. You have to provide reports about where the person's living, how they're doing, what their health is like, and then also the finances. And that's where a lot of people kind of get a little...
If the ball's dropped, it's usually in the financial reporting.
Yeah, because you have to have a separate account. And you have to, if
So it's going to be okay if you're a conservator of somebody to just bring the district judge every 2 years a shoebox full of receipts, right? And go, here's what I spent money on.
No, they'll usually then look at you and say, you need to hire a lawyer. We really try to work with people who are doing this guardian conservatorship within their first year to teach them how to manage this money, because you have to account for all of the person's income, whether that's SSI or some other form of income, all of their assets if they own property or if they don't,
Correct.
and where the money's coming in from, where it's going out to. So you literally have to provide an accounting.
I think an important little detail here is if we've done a special needs trust for the person that then gets guardianship and conservatorship, the conservator would not automatically become the trustee in control
No.
of the trust. What the conservator would manage for that person's then called a ward.
Yeah.
That is the
I don't
legal.
love the term, but
That's the legal name
that's the
for
legal
it. Is
term.
if you have a guardian, you are that guardian's or a conservator, you are that person's ward, their responsibility.
Yep.
If you have, again, the special needs trust, the trustee still manages when the money or property gets pulled out of the trust, how it's invested, how it's managed, all of those things. But at the point the trustee doles that money out to the guardian or conservator's ward, then they would be in control of that portion that had been distributed out of the trust
Yes.
to the beneficiary, which is also the ward.
Yeah, and to be fair, the trustee can be the guardian and conservator.
Could be, yeah.
It doesn't have to be different people. You just have to watch how you're accounting for all of
So
that
what you're
money in
saying
and money
is,
out.
now if you're a guardian conservator for somebody, so it's a good idea to just go to Walmart with your credit card and buy things for yourself and your ward, and then divide all of the accounting back out, right? That's nice
If you
and
want
easy.
the judge to look at you and say you need to hire a lawyer.
Have we seen it?
We've seen it. We have seen it more times than I would like to admit. It's one of those things. We do it when we do it for the business. If I have to go to Walmart and I buy something like we
You
need,
do separate transactions.
you do separate transactions. That's as simple as it is.
Well, but the thing is too. I mean, obviously, as attorneys, boy, everybody will love this, but it's true. Your mind just works different, right?
Yeah.
Maybe a little too different. But in any event, right, your mind works differently, and there's no reason that I think just people on the street would necessarily think, okay, I got to do this. I've got to separate this into this account, that into that account, and keep the finances in this way.
Yeah.
So our job as attorneys and advising people that are trying to do this is to try to simplify it and make it as easy as we can in such a way that it still follows all the parameters that the court's going to be looking for.
Yeah, absolutely. We try to set our clients up for success. You know, we really try to kind of hold their hand through the first year, get them through that, get them through the first report, and then if we think they're good and they want to go ahead and do it on their own, that's absolutely fine. We're there to support them however they need us to. But it's a little bit more than, just handling your own finances. I don't have to go anywhere and tell people how I spend my money.
Correct.
So-
Yeah, absolutely.
We've talked about some complicated things, some special needs
Right.
planning.
So if you have a basic estate plan and you're hearing this podcast and going, wait a minute, I've got a kid at home that's never going to be able to take care of themselves. Or maybe it's an adult child that's never going to be able to take care of themselves, and you already know that. What's the next? Is my basic will probably enough? I mean, where's the shortcoming going to be?
It may be, it may not be. You can always give us a call. Come to an attorney who practices in this area predominantly. We can take a look at your estate plan. Recommend to you if it does what you need it to do. If you need to have a special needs trust, if you need to go to guardian conservatorship.
If it's an adult child,
Yeah.
and again. We talk a lot of times people are most concerned about their children. People with special needs children are just very gut-wrenchingly concerned, and rightfully so.
Yeah.
What's going to happen to my child if I pass away and they're not able to take care of themselves? Who's going to take? If you don't have a special needs child, you may not know what that concern is. If they're adults and they are fully functioning, that's not they can take care of themselves,
Yeah.
right? But with special needs children, that's a big concern. And even if you don't have a tremendous amount of assets, you can fund these special needs trusts with life insurance upon your passing. You can direct that as a beneficiary. So there's options. There's options
Yeah.
and ways we can structure that.
Yeah,
right?
there are. And there are some pooled trusts as well that you can work with. Stable accounts. It's a specific governmental program.
Let special needs people have a little bit of money on hand without pushing them off of their other benefits.
Yeah. So there are ways that we can do that. But the thing is come sit down and talk with us. Let us know what your situation is. We try to tailor everything to our individual clients so that it's customized to you. You can give us a call. We're here at Berkley Oliver. We're in Shelbyville, Kentucky. Our phone number is 502-205-9005. You can also email us info@berkleyoliver.com.
And with that, this has again been Legally Speaking. I'm Josh.
I'm Amy. Thanks for joining us.
Yeah, we hope to talk to you again soon.
Bye.
Thanks.